Imagine going to Disney World, excited for the happiest place on earth, and somehow you end up in the hospital because of a food allergy. That's what one family says happened, so they took Disney to court for it. Today, we're going to dive into civil/business law and talk about the Disney allergy lawsuit that was all over the internet back in 2023. But before we start, I want to take a moment to acknowledge the tragic loss of Dr. Kanokpon Tangsuan and send my deepest condolences to her family. This video is not meant to sensationalize the incident, but to learn from it and understand the important legal issues involved for educational purposes. Hi, my name is Amy, and on this channel, law won't be boring. It's just stories, rights, and lessons hidden inside the world's most talked about cases. Think of this as your personal guide to understanding the legal side of big lawsuits in just less than 15 minutes. I've already done all the legal research for you, so just sit back while I break down your favorite drama in simple, clear terms. Because here's what I believe: everyone deserves to know their rights. When you understand the law, you become harder to manipulate and more confident in your own power. So, let's make legal knowledge something real, useful, and actually interesting, one case at a time. On October 5th of 2023, Dr. Kanokpon Tangsuan, a 42-year-old Thai doctor with severe dairy and nut allergies, visited Walt Disney World with her family. They dined at Raglan Road Irish Pub in Disney Springs. Kanokpon, her husband Jeffrey Piccolo, and her mother-in-law Jackie Piccolo told the staff about her allergies and confirmed with both the waiter and the chef which dishes were safe. She then proceeded to order broccoli and corn fritters, scallops, and vegan shepherd's pie, and also onion rings after multiple reassurances. After eating, Kanokpon and Jackie went shopping while Jeffrey returned to their hotel with leftovers. Around 8:45 p.m., Kanokpon suddenly had a severe allergic reaction inside Planet Hollywood, struggling to breathe and collapsing. A bystander called 911. She used her EpiPen, but it wasn't enough. Her family, not having been there at the scene, quickly rushed to the hospital after hearing the news. But tragically, they were informed that she had already passed away. The autopsy confirmed the cause of death was anaphylaxis from dairy and nuts. Jeffrey then kept the leftover food at the restaurant as evidence. Let's dive into the first legal event of this case. On February 22, 2024, Jeffrey Piccolo filed a wrongful death action lawsuit against both Dragon Road and Disney, suing them for a sum in excess of $50,000, quote unquote, in addition to mental pain and suffering, loss of income, and funeral expenses. At this stage, Piccolo's attorneys started asking for fryer cleaning logs, restaurant recipes, and staff training files from Raglan Road, Disney, and Disney-owned entities. So what exactly was he claiming in the lawsuit? Here's the breakdown. The lawsuit says there was negligence, meaning the restaurant and Disney didn't properly handle Dr. Kanokpon's life-threatening allergy, even though they were warned several times. It also claims wrongful death, saying her passing could have been prevented. There's a failure to warn, meaning they didn't confirm the food was safe or tell her about allergens. Then there's breach of duty, showing they didn't meet their legal responsibility to provide a safe environment and accurate food information. And finally, failure to train and supervise, meaning the staff wasn't properly trained to handle allergies or prevent cross-contaminations. Before that, in November 2023, the court appointed Jeffrey as the personal representative of his wife's estate, which gave him the legal authority to pursue the case on behalf of her estate and survivors. In April 2024, Walt Disney Park and Resort officially joined the case. They started actively taking part in the lawsuit by asking both the plaintiff and its co-defendant, Raglan Rhodes, for documents under a legal rule called Rule 1.352, bracket 3, so they could be fully prepared for their legal defenses. Disney submitted its official response to the lawsuit and added affirmative defenses, which are reasons why they believe they shouldn't be held liable. They did not mention anything about sending this case to arbitration at this point. So here's how Disney responded. Well, first, they admitted that they own the land where Raglan Road is located. and that the lawsuit was filed in the right court. But they argue that because the restaurant is leased to great Irish pubs, that company actually controls everything, from hiring staff to running the menu to supervising employees, so Disney isn't legally responsible for how it was run. For all the claims about negligence, like the idea that Disney should have known or that the public would think Disney controlled the restaurant, they basically denied them. They pointed out that the lease makes it clear the restaurant is independent and any claims that Disney was responsible are, according to them, legally incorrect. Disney also listed a bunch of defenses, like they didn't control the restaurant, didn't know anything was wrong, and didn't cause harm. They argue that the damages the plaintiff is asking for might not even be valid under Florida law, and that other parties or even the victim herself could share that responsibility as well. They also reserve the right to add more defenses later if needed. In short, Disney is basically asking the court to dismiss the case completely, rule in their favor, and prevent the plaintiff from suing them again over this. Instead, they included a prayer for relief at the end. Now, all of a sudden, 1 month later, on May 31st of 2024, Disney filed a request asking this court to stop the lawsuit and force the case into arbitration instead. They're leaning on the Federal Arbitration Act. Okay, but first, what is arbitration? Basically, it's like a private court. Instead of going in front of a judge and jury, both sides agree to let a neutral person called an arbitrator decide the case. Companies like it because it keeps everything out of the public eye and is very private. But here's the catch. If you agree to arbitration, you usually give up your right to sue in a regular court, and whatever the arbitration decides is final. That's why some people think arbitration protects big companies more than regular people. With this being said, they gave two reasons for the request. Firstly, they claimed that Mr. Piccolo signed up for Disney Plus on his PlayStation, and by doing so, he supposedly agreed to settle any disputes through arbitration. Secondly, Disney claimed that he bought Epcot tickets on Disney's website before his wife passed away, which had a mandatory arbitration clause and rules that said he couldn't sue as part of a class action. By continuing to use Disney's services, Disney said Piccolo accepted these terms. Disney also pointed out that the arbitration terms give the arbitrator, not the court, the authority to decide if arbitration applies. And they argued they haven't waived their right to arbitration, since they only responded to the complaint and haven't acted in court in a way that would give up their right. Finally, Disney says the court should pause the lawsuit while arbitration happens. Even the claims against Raglan Road should be stayed because the cases involve the same facts and having both go separately could cause confusion and waste time. After Disney tried to push this case into arbitration, Jeffrey Piccolo fought back in August of 2024. Their main point? The agreements Disney relies on don't actually apply here. First, the 2019 Disney Plus account that Jeffrey signed up for was just for streaming. He clicked agree and continue for the subscriber agreement and privacy policy, but never knowingly agreed to Disney's broader terms of use that mention arbitration. This is called a click wrap agreement, which is a digital contract formed when users click a button or check a box to indicate their agreement to terms and conditions. You guys must have seen this many times already. However, those terms were hidden in a link and not clearly presented, so he never saw it. This is called a browse wrap, which is when terms are just linked somewhere on the website, but you don't have to click to agree to them. Example, if terms are hidden at the bottom of the page or in small gray font, it's not enough to show someone actually agreed to them. And courts often don't enforce browse wrap agreements unless it's very clear and visible. But in this case, the important terms of use which mention arbitration were buried inside another link and not shown clearly when Mr. Piccolo clicked agree and continue. And even if he had clearly agreed, that contract only covered Disney Plus issues and not real world injuries at a theme park. They also said that WDPR is not even part of the Disney Plus agreement. The Disney Plus agreement was between Mr. Piccolo and companies Disney DCL LLC and BAMTech, the streaming side. WDPR is not named in that agreement. In most cases, only people or companies who signed the agreement can enforce it. There are rare exceptions, but none of those exceptions apply in this case. Second, the 2023 My Disney Experience app terms, which Piccolo agreed to when buying tickets, actually say any lawsuits must be filed in Florida courts. They don't mention arbitration at all. That directly conflicts with Disney's other terms, which does mention arbitration in New York or California courts, and both can't apply at the same time. So the estate argues the more specific app terms, which is the My Disney Experience one, should control this case. This is also confirmed by Disney's own rules in the terms of use that if another set of rules, like app terms, conflicts with this one, the more specific terms win. The essay also argues that Disney waived any right to arbitration. Disney already participated in the lawsuit by requesting documents, responding to the complaint, and gathering evidence before trying to move the case to arbitration. Florida law says that kind of action can count as giving up the right to arbitrate. Next, the estate points out that neither Piccolo nor his wife's estate ever signed an agreement with Disney Parks and Resorts. Florida law generally says only signatories can be forced into arbitration. They said Disney's argument is flawed. Here's why. Disney points to the fact that Mr. Piccolo signed up for Disney Plus years ago as an individual, but that has nothing to do with the estate of his wife, which didn't exist at the time because she was still alive and never agreed to arbitrate anything. So, a personal Disney Plus subscription can't bind the estate. They also mentioned Florida's wrongful death law, and under this law, only the personal representative, Mr. Piccolo, can file a lawsuit on behalf of the estate and survivors, but that doesn't mean he can use agreements he made personally, like the Disney Plus subscription, to limit the estate's rights. Finally, the estate argues that the arbitration itself is unfair and unreasonable. To prove that something is legally unconscionable, you have to show two things. First, procedural unconscionability or unfair process, meaning the way the contract was presented and agreed to was unfair. And second, substantive unconscionability or unfair terms, meaning the content of the contract itself is extremely unfair. For procedural unconscionability, the plaintiff argues that arbitration clause was hidden in fine print inside a long document linked to a Disney Plus sign-up page, so Jeffrey didn't really understand he was giving up his right to a jury trial. It was a contract of adhesion, which is a take it or leave it agreement, so he had no power to negotiate. For substantive unconscionability, the plaintiff says the arbitration clause is extremely broad and tries to cover all Disney companies forever, even unrelated to Disney Plus. It basically forces Disney Plus users to give up their right to a jury trial for life. Disney also wants the case in JAM's arbitration, which has strict limits on gathering evidence, such as having only 14 days for both sides to gather evidence, with limited ability to get the documents or testimony needed to prove your case. Discovery in JAMS is designed to be fast, which is not fair for serious cases like this wrongful death claim. In August of 2024, Disney decided to drop its motion to send the case to arbitration and allow the wrongful death lawsuit to proceed in court. This is because the company faced widespread criticism when the public became aware of its attempt to force the case into a private arbitration rather than a public court. So, this is another one of their ways to avoid further damage to their reputation. The chairperson of Disney's theme park division, Josh D'Amaro, released a statement saying the company would waive its arbitration rights out of a sensitive approach to the family's pain and find a solution to the issue. As of now, October of 2025, there's still no confirmed trial date or final ruling in this case after Disney allowed the lawsuit to proceed through court. However, after the incident became public, Raglan Road updated their website to clearly state that they, quote unquote, cannot guarantee that any dish we prepare is free from gluten, allergen, or free from cross contact. This is a positive step, especially for people with allergies, because now they can make safer choices and avoid even the smallest risk. So, I hope after hearing this story, you're starting to take terms of use more seriously. And that's a good thing. Being aware of what you're agreeing to can protect you from scams, legal trouble, or even serious consequences. Just spending a few minutes reading those terms when you apply or signed up to something could actually save you from situations that are way more serious than you might think. This case also shows how far companies can go in order to protect themselves, sometimes using tricky clauses like arbitration agreements to avoid lawsuits and protect their reputation. It's a reminder that we should hold corporations accountable and know our rights so we don't get taken advantage of. Thanks for sticking with me through this whole story. I hope you now understand not just the legal side of things, but also why it's so important to know your rights and to always be careful with things like allergies, contracts, or terms and conditions from now on. Remember, even big companies have rules they need to follow, and being aware of your rights can protect you in ways you might not expect.